Hey, Drano, now that I have you here, teach me about personal injury. I want to know everything.
Well, it's kind of a loaded question, but sure, let's get into it. With personal injury, there's two major types of claims that we'll see. One being motor vehicle accidents, another being slip and fall or trip and fall accidents. Now, that's not lessening the importance of other claims like dog bites or medical malpractice claims, but the vast majority of claims we'll see are motor vehicle accidents and slip and fall, trip and fall type accidents. Now, there's two completely different regimes that dictate and govern these different areas of personal injury, and I think that that's where some people really, get confused and have a lot of questions about. That's fair because there's a distinct area of law that applies for motor vehicle accidents, mainly the Insurance Act, and a regulation of that being the Statutory Accident Benefit Schedule. Much of what we do is comprised within those two acts. In slip and falls, it's going to be solely, tort law, or what we call negligence acts, so Occupiers Liability Act, and typically you're going to have one action. Could be against many parties, but you're going to have one action in the slip and fall, whereas with a motor vehicle accident, you first have a claim with your own auto insurance provider, and then you also have a potential lawsuit if you're not at fault for the accident.
I see. Okay, so you mentioned tort. Can you explain what a tort is to me? Because I sort of don't understand that and what the difference is between normal court and a car accident case, for example.
Yeah, good question. So the law of torts is essentially the law of negligence, and particularly with car accidents, what you're seeking to prove is that, but for the actions of someone else, that accident wouldn't have happened, and as a result, the injuries you sustained wouldn't have happened. So you really got to tie it towards the act of the actual car accident and the negligence on one of the parties, maybe multiple parties, in terms of causing that accident.
I see. And then with regard to tort, you wouldn't employ something like a tort for a car accident claim?
Yes, you would, but only if another party's at fault. So, we also represent people in, single vehicle car accidents or accidents where they're at fault. That is where they will still have benefits available to them with their own accident benefits provider, their own auto insurance. Typically, we'll build a claim there with treatment, potential income loss claim, and then there will be a potential settlement for that claim as well. But tort is only when there's another party to sue, essentially.
Oh, I see. So even if I was at fault for the accident or I crashed my car by myself, you'd still be able to help me in this case?
If you're hurt, then we can still help you get treatment for your injuries. If you're missing work, we can still help you get income replacement. And some people were, I don't want to say wise enough, but maybe well advised or had the means to buy optional benefits. And that could open up a whole range of other benefits that we could apply for and help you get as well. We don't see that often. It's a small percentage of claims, but we really encourage people to pay that little extra and get those optional benefits, because if you do need them, they're going to be extremely helpful for you.
I see. Now, let's say I am involved in a car accident. Can't I just fight the insurance company by myself? Or why do I need to call you to help me out to do it for me?
Of course, you definitely can fight them on your own. And we see this often where clients will call us a year into their claim, maybe beyond that. But more so, we'll see they'll call around the 3-month mark or so. And that's really important because the insurance company will typically play all nice and friendly at the beginning. And they're going to say, we'll set you up with a treatment center that we recommend, and we're going to help you, and we want you to get better. And lo and behold, the 2 or 3 month mark, most clients are cut off from treatment because those treatment providers have now said, hey, you're fully healed. You don't need any more treatment. And they submit a form to the insurance company saying, you no longer need treatment. You're ready to get back up with your life. And you get those calls from clients who say, I'm not feeling better. I'm still struggling at work. The insurance company says I have to go back to work or I can't get any more treatment because the provider or the treatment center they sent me to saying that I'm better. So we get involved a lot of times at that stage. And although we want clients to call us right away to protect their rights, it's not too late at that point, and we can still help you out.
Oh, I see. So you're saying up until the 3-month point is the max time I have to call you, or what are these sort of time limits?
I wouldn't say the max time, but I would say a lot of times after the 3-month or 4-month mark, a lot of damage has already been done. So it's a lot harder for us to repair the claim and get it back on track. Again, some people have called us after a year. Some people we've helped after 2 or 3 years even. You know, we'll always look at your claim. We'll always see if we can help you. Again, best advice, call a lawyer, a personal injury lawyer right away following your car accident so that you know all of your rights and everything that's available to you. Failing that, call them as soon as possible. If you start the claim on your own, it doesn't mean you can no longer call a lawyer. If the insurance company tells you that, or if the insurance company is trying to offer you a small settlement, speak to a lawyer first. It's very likely that they're lowballing you, trying to close your claim for much less than it's worth.
Makes sense, right? Obviously, the insurance company doesn't want to pay out, and obviously, like, I'm not a lawyer, right? I don't have this leverage with the insurance company to be able to negotiate and be able to, like, get the benefits that I deserve, right? Or I'm entitled to. So I think it's definitely important that you're calling a lawyer right away for sure. Now, moving back to slip and falls, because that's another aspect of personal injury. Is it the same sort of time limits, or how long do I have after I say slipped and fell to call someone like you or to make a claim with the insurance company?
Okay, that's a good question. And this is where a lot of people run into trouble, unfortunately. So there's different time frames. Again, never wait until the end of one of these time frames. Call a lawyer right away. But the most urgent one is if you fall on any city property, and if you're unclear if it's city property or not, you have to assume that it is. It's 10 days. If you don't notify them within 10 days, it is almost always fatal to your claim. Okay, now there are some exceptions. You can speak to us about that or speak to another personal injury lawyer, but it's very often fatal to your claim. So within 10 days, and there's a specific notice requirement where it has to be written to the city clerk of that city. It often needs to be sent by registered mail unless there's an email that they advertise and they confirm acceptance of it. So it's very stringent requirements. You have to give full details of what happened, exactly where it happened, your injuries, and any damages that you know of at that point. Again, get legal advice on that because the requirements are stringent, and if you miss them, your claim could be fatal. Now, if you fall on city property and it's as a result of snow and ice, then you have to put them on notice within 60 days. And this is a new requirement that just came in a few years ago. And unfortunately, a lot of people have missed that deadline. And then in general, other slip and falls, you have 2 years to start a lawsuit. But again, always advise you to start much sooner. There's always complications in finding who owns the property, who's the property manager of the company, who's the contractor of the company, is there visas in place. So you want lots of time to provide to your lawyer to do all those investigations, to name all the proper parties so that the litigation goes well.
So it's my understanding that if I'm injured, whether it be a car accident or a slip and fall, I need to either call a lawyer or file a claim with the insurance company as fast as possible, right? So I meet these deadlines.
Exactly. Now, you might not know who the insurance company is, so you have to put the actual parties on notice. But again, a lot of these parties are sort of hiding behind contracts, so you wouldn't know who to put on notice properly. But with city property, you've got to put the city clerk on notice.
So in this case, your best bet is essentially calling a lawyer because someone like you knows how to contact the right people that need to be contacted, put the right people on notice. Now my question is, I don't have so much money, and I know lawyers are extremely expensive, right? So if I'm getting legal advice from a lawyer, or I'm calling in, or I'm trying to set up a consultation with you, I don't have the money to be able to afford your fees for this consultation or to afford you to represent me. So what do I do in that case?
So we don't charge a fee if we can't find your case. We always do it on a contingency fee basis, which means we're only going to charge you if we recover money for your case. Okay.
Well, I see.
Now, I want to be fair and, say that most reputable personal injury firms in Ontario will do that. If you're seeing a personal injury law firm that is asking you for money up front or asking you to pay hourly, I would strongly suggest you see another firm, get a second opinion, because that's not right. You know, you're at your most vulnerable time. You're maybe not working, you're hurt, you're injured. You don't have, most people, I should say at least, don't have that luxury of paying a lawyer hourly while this claim is going on. Maybe your claim's going to go on for a year, 2 years, 3 years, 5 years. So it's going to create an undue burden on yourself if you're paying hourly. So, Apprentice Law Firm, we only charge contingency fees on personal injury matters, so you'd never pay us a dime.
I see. And now what happens if I come to you guys, I'm on contingency, you guys are supporting me with my case, but we lose the battle together, like we lose to the insurance company. What happens then? Am I responsible for paying you?
So, in that unlikely situation that has happened here and there, no, that's a case where you're going to get to walk away. Nobody's going to be happy. Certainly, we're not going to be happy for working on your case for X amount of time and not recovering anything. But that's plain and simple. It's on our contingency fee agreement. It's right actually at the top header of the first page is this contingency fee agreement. We will not charge you a dime if we're not successful.
I see. And now let's say I am injured, right? However, I got injured and you guys are supporting me. We're fighting with the insurance company to try to recover some money that I'm owed. Now I'm understanding that I'm supposed to go to doctor's appointments and I'm supposed to get checkups with physiotherapy and so on and so forth. Now, obviously these things cost money, right? So how do I pay for these expenses now to be able to support my case?
So that's another good question. In every case, we're going to look at the injuries that you have. We're going to give you the best advice in terms of what we think you should see, but we want you to follow your doctor's advice. Your doctor, your family doctor, or maybe another doctor that you're seeing is really going to help guide you in terms of what treatment options you should seek. Typically, if it's a motor vehicle accident, you're going to start with physiotherapy, chiropractic, potentially massage therapy. Those different modalities of treatment that we'll look at as well. Aquatherapy, perhaps chronic pain care clinics, orthopedic surgeons, physiatrists. So the different injuries that you have will dictate where we think you should be seen. Many of these doctors are OHIP covered. And again, if your doctor thinks it's necessary for your case, they'll refer you to a doctor of their choosing, and it would be all OHIP covered. In terms of physiotherapy, chiropractic, if it's a motor vehicle accident, again, we'll fight with the insurance company to make sure that they pay for it. And if they don't pay for it, then we'll usually work with the clinic to try to hold off on payment, or maybe we'll pay it on your behalf while you're applying for treatment. And same thing with slip and falls and trip and falls. We'll try to bridge the loan on your treatment to make sure that you don't have to pay it until the case settles. Or, in some cases, we'll pay it up front for you to get the care that you need so you can get better, move on with your life, hopefully, and let us worry about settling your case.
Okay, so that all makes sense. Now, the impression I'm getting is that it's sort of a no-brainer. If I'm injured, whether it be a slip or fall or a car accident, it's a no-brainer for me to call a lawyer like yourself, right? It's a free consultation. If there is a case there, you work on contingency basis, so I'm not paying for anything out of pocket.
Right.
And on top of that, you're going to refer me to the best healthcare providers for treatment for my injuries. And in worst case scenario, if it's not covered by OTIP, we'll figure out ways to be able to cover it through loans and stuff like that until the case is settled.
Right.
So basically, everyone should be calling a lawyer like yourself when they're injured.
It's a good question, and I'm still amazed. Sometimes I still meet with clients that have injuries, and for some reason, they don't want to go ahead with it. Some people don't even want to approach a lawyer. They don't like us. They think we're out to get them. But I think you said it best. We want the clients to be successful, right? If the client's case is successful, we're going to be successful as well. But, we get to know our clients. We care about them. We want them to do well. And we're really going to work hard to make sure that not only are we trying to settle their case for a fair amount, but we're getting them the treatment they need to get better. You hit the nail on the head. There's really no risk to our clients. The risk is all on us. So typically clients will say, how much is my case worth? Or should I do it? And I'll usually tell them that, well, pretty nice guy, but I don't like to work for free. So if I don't think I could settle your case, if I didn't think your case was worth money that we would be worthwhile for both of us, I wouldn't put you through it. I wouldn't take on the case. So when we take on a case, we see the potential in it. We think that we're going to get a good result, and we work hard on the case to make sure we get that good result.
Excellent. So if someone is injured, right, they're in a car accident or a slip and fall, what's the best way to get a hold of you? Is it by calling into the office? Is it by giving you a call, social media? What's the best way to get a hold of you personally?
All of the above. We fully welcome people walking in. I have a big staff here now, so we're always here for clients that want to walk in and meet with us. You can DM us on social media. We're very active on Instagram and TikTok as well, and YouTube. You can give us a call. We have a toll-free number anywhere across Ontario. You can give us a call for free. Get in contact with us. It's no obligation, no pressure.
Excellent. Well, that's great to hear.